Sir, I beg to move that the Legal Services Authorities Amendment Bill 2002 be taken into consideration by this House and be approved by this Honourable House. Sir, this bill has already been approved by the Lok Sabha. The Parent Act, sir, was legislated in the year 1987, and there were two principal purposes of the Parents Act. The instrument under the Parent Act was that we constitute a National Legal Services Authority. Thereafter, there would be state-level legal service authorities and legal service authorities at the level of every district of the country. Accordingly, in the last 12 years that the bill has been put into operation, its functioning has been highly successful, and these authorities have been created all over the country. The Chief Justice of India is the patron. One of the judges of the Supreme Court heads this legal service authority. Similarly, the Chief Justice of every High Court is the head of the state-level authority. There are two principal aspects of this bill. That's the original 1987 bill. One was to make provision through the state-level and district-level authorities for giving legal aid to poor people. This experience has been somewhat successful with the creation of these authorities, and till today, over 40 lakh cases of legal aid have been dealt with by the legal service authorities all over the country. The second aspect of this bill has been to constitute Lok Adalats for an out-of-court conciliation and settlement of legal disputes. Sir, at the level of various districts and states, also at the level of different sectors, insurance sector, banking sector, motor accident claims, land acquisition cases, there have been several Lok Adalats which have been held all over the country. And today, till today, in the last 12 to 13 years, we have been able to resolve by a process of conciliation as many as 1,36 lakh cases only through the Lok Adalat processes. The advantages of this Lok Adalat process has been that this is a cheaper remedy, this is a quicker remedy, this also is friendly to the consumer of litigation, that is the litigant himself, and is in fact very, very cost free as far as the litigant is concerned. Sir, after considering the success of the Lok Adalat experiment, one new chapter has been intended to be added to this legislation, which relates to pre-litigation Lok Adalats. Pre-litigation Lok Adalats, as different from the earlier Lok Adalats, would be that every time a citizen has a grievance with a public authority. Now, these are, in this chapter, it is conceived only to have pre-litigation Lok Adalats in relation to public utilities. We have selected public utilities because normally it is governmental or quasi-governmental bodies in most cases which are the public utilities in this country, from municipalities to housing board to development authorities, insurance companies, telephone companies, electricity boards. The citizen has a large number of litigant grievances as far as these public utilities are concerned. In relation to these grievances, he is normally expected to approach the court, and litigation therefore becomes very time consuming and very costly. The second system, which is already in the 1987 bill, is the court can itself refer it to Lok Adalat for conciliation, but two weaknesses have been seen in that entire system. At times, officers of public utilities are not willing to even settle when financial concessions are to be made, even if they feel that these are genuinely to be made. And secondly, if the conciliation fails, the Lok Adalat process fails and the matter goes back to the normal court. Sir, in these Lok Adalats, it is being made mandatory that for every public utility or for a cluster of several public utilities in a given state or a city, there would be a Lok Adalat. It is now mandatory to have them there. These Lok Adalats would be 3-member Lok Adalats presided by a former judicial officer with 2 other experts as members. This is in addition to the normal route of litigation which is available to a citizen, the normal route of a conciliatory Lok Adalat which is available. This is a fresh route being provided that instead of going to court and litigating there, before he goes to court, he can raise his grievances before this Lok Adalat. The Lok Adalat, which will be mandatorily in existence and functioning all 5 days a week in every public utility, he would try and settle his grievances in those Lok Adalats. If a conciliation comes about, the conciliation will succeed. If a conciliation fails, the Lok Adalat will, after hearing both parties, give its own award or decision on the matter, which would be binding and enforceable as a decree of the court. Sir, this route is being provided that this would help an ordinary citizen, a poor citizen who does not want to waste time and money in courts and would want to settle small disputes by an out-of-court forum of this kind. Sir, Sir, the successful experience of Lok Adalats under the 1987 Act has in fact guided us to strengthen this mechanism further. I therefore commend to this Honourable House that this bill be taken up for consideration and approved by the House.